If you were about to go through a property settlement process in terms of your separation, you're ultimately going to be dealing with the Family Law Act when it comes to how lawyers and ultimately how a court would consider dividing up the property between you and your spouse. When we use the word property, we as lawyers mean everything that you two own. So things like your house, your car, your contents to some degree, savings, shares, it's anything that you own comes into this conversation. So there are 4 steps that we work through as lawyers when we're trying to advise you about your property division. The first step is for us to understand all of the property that you have. So we do that by writing a list of all of the assets, all of the debts, all of the superannuation and anything else you have that might be worth money. The value of those things is on the day that you sit down and talk to us. And if you're in a court process, the value of those things would be on the day you find yourself before a judge in court. The second thing we then look at is how the two of you, together as a couple, created the things on that list. And in a legal sense, we use the word contributions. Contributions means how you've, in essence, contributed, obviously, to the growth of the asset pool that you have. It might be that one or either of you had assets at the beginning of your relationship, and we call those initial contributions, something that you brought in. Or it might be that throughout the course of your marriage or the course of your de facto relationship, there was a contribution made, such as a gift from family, a loan from family, or some other sort of larger amount of money that's come in. Other common types of contributions are income earned from employment, or it might be that one of you is a stay-at-home parent and contributions in a homemaker and parent are just as valid and just as important as those made earning income. So we weigh all of those things up and balance them up, and it is quite a fine art in terms of how we do that. The third thing we then look at is the future needs factors, as they're often called at law, or the future, the financial future of each of you. I like to call this the crystal ball step, and it's obviously not the crystal ball step in the legislation, but if you think of it this way, what we're trying to do is look into a crystal ball using the information from your past to try and predict your financial future. So things here that are really important and relevant might be whether there are children of your relationship, and if so, who's looking after those children and how they're financially going to be supported. The other things that are relevant are things like work, whether either of you are working, both of you are working, what sort of income you're receiving, how old you are, whether you have any health conditions. And there's quite a lot of other things there, but they're the main things, I guess, that we consider. And again, we weigh all of that up. Finally, at law, we have to consider whether a division of the property that the two of you have is just and equitable. And importantly, they're not the words fair. It's not about trying to find something fair. It's about trying to find an outcome that is appropriate at law. And for every family, it's different. My name is Clarissa. If you have any more questions, please don't hesitate to get in contact.